Everybody, it's Timothy Holt. I don't have some grand title other than my name. So today, please keep the comments civil. Please comment. I'd love to have civil discourse going on here. We're going to be discussing the Supreme Court case that was heard yesterday. Oral arguments were heard yesterday in the case of Masterpiece Cakeshop v. Colorado Civil Rights Commission. If you haven't been following this, it's an interesting case in development. And so the Masterpiece Cakeshop is owned and operated by Jack Phillips in Colorado. Back in 2012, Charlie Craig and David Mullins approached Jack Phillips to contract him to decorate a cake, specifically a wedding cake for their homosexual wedding, same-sex wedding. I'm not going to be discussing the moral aspect of that situation today, because Colorado law says that two guys can get married, two gals can get married. So it is legal for them to get married. So I'm not going to argue that case. What I am going to do is discuss the actual merits of both sides here. So I'm going to start with Charlie Craig and David Mullins side of this situation. They are represented by the ACLU in this case, and they believe that their rights have been violated based on Colorado's Anti-Discrimination Act, which states that public services cannot be discriminated against based on sexual orientation. So if you're homosexual, you have just as much access to public services as anyone else. Public services cannot discriminate based on your sexual preference. That is their case. They are saying that they went into the bakery, they were told no because they're gay, and he should be shut down and basically have his pantsuit off of him. Okay. That is their entire argument. Okay. So, by the way, I'm referencing an article in the Washington Post concerning this. There's quite a few other articles. I just happened to pull up this one. So, because it has some key information here. The ACLU argued yesterday during oral arguments that Craig and Mullins had their rights violated in accordance with Colorado Anti-Discrimination Act. So the Colorado Civil Rights Commission shut down Masterpiece Cakeshop. They shut them down. Just straight up required them to pay exorbitant fines, considerable amount of fines, and shut them down. So Masterpiece Cakeshop with Jack Phillips obtained legal counsel and sued the Colorado Civil Rights Commission. And that is what was heard yesterday. The Phillips run the bakery in a Denver suburb, and they are probably the most well-known case, but not the only case going on right now in Colorado. Apparently there are florists and calligraphers, singers, performers, other people who do work for hire, suing the Colorado Civil Rights Commission because of this rule that they are not legally allowed by Colorado law to say, no, we will not perform that task for you. So to give you an equivalent here, it would be like a singer saying to the NFL, no, I'm not going to perform during the Super Bowl halftime show for whatever reason. I'm not going to do it. They can say, I have other obligations. I don't want to. I have no interest in football. It doesn't really matter. Okay, so the case is that these two individuals were discriminated against because they're gay. Fair enough. That is their entire case. Non-conformity with gender norms in appearance and demeanor. The ACLU is referencing Jamaica Evans' case, which dates back to 1979 as precedents in the 11th Circuit Court. And their entire argument hinges on the Title VII Civil Rights Statute that covers workers and protects basis on sexual orientation. So they're saying that an employer cannot discriminate an employee against them based on their sexual orientation. That's their entire argument. However, now let's flip the coin, okay? Now let's go to the cake baker. So the baker, Jack Phillips, is asserting that he has religious freedom to say no. Okay? Basically, his case says that the First Amendment, specifically the Free Exercise Clause, for those of you who aren't familiar with the First Amendment to the United States, the First Amendment to the United States Constitution has a clause that says concerning religion. Actually, there's two clauses concerning religion in the First Amendment. And the first one is establishment, which says Congress cannot establish a religion. And then the second one is free exercise. The actual wording is, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peacefully to assemble, and to petition the government for a redress of grievances. That's the actual wording of the First Amendment. Okay? And Jack Phillips is saying his First Amendment rights, specifically the free exercise thereof aspect, has been violated. However, and his attorneys, the FBA, I believe it is, his attorneys are not listed here in this article, but I've seen them elsewhere. They're a pretty well-known organization for representing religious people in court cases. Excuse me. I would say that, yes, his First Amendment rights have been pretty much trampled on. However, more specifically, I have a question for everyone here who's watching this video, and that is, have his 13th Amendment been trampled on? For those of you who don't know about the 13th Amendment, the 13th Amendment came in the wake of the United States Civil War and was ratified into law in 1868. And the 13th Amendment to the United States Constitution is a pretty interesting one. It's pretty straightforward as well. So there's not a lot of ambiguity in the 13th Amendment as far as what I'm going to be putting out here. So I don't like misrepresenting things, so I'm pulling up the actual text of the 13th Amendment for those of you who aren't familiar with my way of doing things. So there's two sections to the 13th Amendment, and it reads, neither slavery nor involuntary servitude, except as a punishment for a crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2. Congress shall have the power to enforce this article by appropriate legislation. That is a direct quote of the 13th Amendment. I would argue that his 13th Amendment has been violated, specifically involuntary servitude. So, according to Merriam-Webster's dictionary, as well as others, the basic definition of involuntary servitude is forced labor, forcing someone else to work for you, whether you compensate them or not. Okay? Forcing them against their will to perform work. Okay? So, if I walk into a florist and I require them to give me flowers in a certain arrangement, and I pay them, however, they tell me, say I offer them $100,000, and they say no. For whatever reason, they give me whatever reason, but they say no. We are not going to do that because that's not what we do. That's against our business plan. That's against our policies. Whatever. We are not going to provide flowers in those arrangements for that event. And I say, but I'm paying you $100,000. And they say no. And I say, you're going to do it anyway, or I'm going to shut your business down and fine you and ruin your life, forcing you to do it. That to me is involuntary servitude. Doesn't matter if I paid that florist $100,000 or not. I still forced them to provide labor, provide services against their will. Okay? So my argument here is not just the religious aspect of it. Would we expect a Jewish baker to be forced to bake Nazi cakes with swastikas all over them, and death to the Jews, and Holocaust was wonderful? No, we wouldn't. Would we expect a Muslim butcher to be forced, to be required to butcher hogs for a hog roast? No, we wouldn't. For those of you who don't know, halal, which is the diet requirement for Muslims, prohibits consumption of pork. Okay? So it doesn't just prohibit the consumption, it prohibits the association or contact with pork. Muslims are not allowed to touch pork, let alone eat it. So a Muslim butcher would not butcher pork, pig, and produce pork because it's against, it's not halal. So would we find that acceptable? I wouldn't. I'd find that involuntary servitude. I would find that not just a breach of the First Amendment, but also a breach of the 13th Amendment. Okay? I would also find it a breach of the Fifth Amendment. Or not Fifth Amendment. Fourth Amendment, which is unlawful search and seizure. And due process of law. So, both of these are clearly federal issues. So I have no issue with the Supreme Court hearing this matter. To me, this is not a states' rights issue, or even it is a federal issue. So, let me get your thoughts on this. Would you consider it involuntary servitude to force someone to provide labor for you, to provide a service for you, excuse me, against your will, even if you're paying them? Or do they have the right to refuse service? Do they have the right to say, no, I don't want to do that, and I'm not going to. Let me know your thoughts. I'd love to hear from you. And I'm curious to see what the Supreme Court's going to do with the 8 judges on the bench. So, in either way, no matter what they do, they will issue a majority opinion and a dissenting opinion. So, in every case, even if it's a unanimous decision, there will be a dissenting opinion rendered. And that's the flip side of the coin, the opposite of the majority. So, the majority carries the weight for precedents, but the dissenting opinions are still matter. They've been used in previous cases. They've been cited in law textbooks and various things of that nature. So let me know your thoughts. Comment in the section below. Check out our other videos and let me know what you think.